Welcome back. Time to lawyer up now with Tom and Deborah Treese of Treese and Treese Law. And today we're talking about a measure that's on its way to Governor Scott's desk that could change child custody laws here in the state of Florida. It's a major legal shift in the way family courts here in Florida determine custody when a couple divorces. Tom and Deborah, thanks so much for being here to help us understand what could be happening very soon if the governor signs this into law. Now, Tom, let's begin with you. What does the law say now when it comes to child custody when a couple splits up?
Well, actually, child custody is a legal misnomer because we haven't had custody in about 10 years. That term is obsolete.
It's antiquated, okay.
What we have now is a parenting plan. And there are two aspects to a parenting plan. First is shared parental responsibility, which is generally automatic. And that means that parents share in major decisions affecting the welfare of the kids. And they share in information. Here's the grades, activities. They do all this. And everybody gets that unless one parent is unfit. The other aspect to that is time sharing. And that's really what you're talking about.
Right. How much time with each parent?
Yeah, well, the standard used to be that one parent had custody, the other had visitation. Now they share, and one parent's time is their time. It's not visitation. The other's is their time, and it's not visitation. It's a sharing of the child's actual time. The standard to that is to promote frequent and continuing contact with both parents.
With both parents, but Deborah, let me jump in because this law would have a judge presume a 50-50 split for both parents. That's a radical change from the precedent, at least in the past. Anecdotally, you hear about one parent having maybe 60 to 70%, most often the mom, but not always.
Well, the change in the law now in establishing this parenting plan and the timeshare schedule is not a mandatory anything.
Okay.
It is just a premise that the court will start with, that each parent should have almost equal time with the minor child.
Right.
Now, this is absolutely to be used again with the standard, which has not changed, which is what is in the best interest of the child. Now, in determining what is in the best interest of the child, the court will look at approximately 20 factors that are right in the statute, and everybody should look at that, because it goes to the issues of which parent will be the parent that will accommodate and help flourish a parent-child relationship between the parent and child with the other parent. Which parent will be cooperative and respectful of time-sharing schedule and obligations? Which parent is actively involved in the child's life in terms of academics, extracurricular activities, health care, friends, teachers, doctors, all of these situations that go into making the child's life productive and constructive. And really, if you look at the law, what it's doing is it's showing parents how to be better parents in a divorcing situation, which is
they've got to communicate.
Correct.
After the divorce.
It's
and do
essential.
you expect the governor to sign this into law?
Very likely.
Very likely.
Because the reasons, the objections that were previously, in previous versions in prior years, were objected to by the Florida bar, family law bar, and they've been fixed pretty much.
All right, it's a big change in the state's family law, and one parents need to be aware of. Tom and Deborah, thanks so much. Tom and Deborah Treese will help us lawyer up every month here on River City Live. If you've got a legal question, find them online at divorceattorneyjacks.com or call them up at 904-737-1771. We're back in a moment.